presentation, I'm sure that you all know what I'll be talking about. I will be only dressing it in the and give it legal basis. The rest you all know. It's morning, it's rainy day, but what do you think of a right? वो अक्सर कहते हैं हक मांगना तौहीन है, हक छीन लिया जाए. नहीं? कहना पड़ेगा. Right. Right is something which you consider that I should get it. This is my right. और ये हम in our daily life, we use it a number of times, consciously, unconsciously. But that is what drives our daily lives. The job that you do, the office that you enter, the workplace that you go, the profession that you have chosen, and then the ability to practice that profession is basically a right. कुछ लोग यूनिफॉर्म पहन सकते हैं, कुछ लोग नहीं पहन सकते. क्यों? Just because that some people have the right to wear the uniform, the other people don't have the right to uniform. If you wear that, then you are doing something which is wrong, right? So we will be talking about rights, and again, to begin with, you all know what I'll be discussing. So please keep that in mind, that you all know what I'll be discussing. I'll be dressing it in the legal sense, that in law, this is what, when you are thinking of your rights, this is what the law says. So at the end of the session, I believe that you will have a little more clarity on the definition and the word right. If there is no clarity, please be frank to let me know. I will work with the administrators of this conference to give you more written material that may help you. Okay? So the definition, the first one, rights and duties to which everyone is entitled to by virtue of being a human being. So to begin with, there are rights which are with you just by the virtue of you being human beings. All the basic standards and moral guarantees which are necessarily required for human beings for dignified living: right to life, liberty, expression, and movement. This we just discussed. Human rights are universal, irrespective of the status of human beings. Now, these are broad categories. I'll be going in, delving more into the details, what it really means. The fundamental rights. How many of you have heard this word before? Fundamental rights. This is a legal terminology which originated with the evolution of the constitutional and legal laws. When the Constitution came into being, when the legal laws came into being, so there was a terminology called fundamental rights. The rights that are universal with all human beings just by virtue of they being human beings. Those rights which are guaranteed by the Constitution and law and judicially enforceable by the operation of law. There is a famous maxim. There are many maxims in law. One of the maxim is ubi jus ibi remedium. If there is no right, there is no remedy. So if you have no right, you cannot claim any remedy. So for a claim, you need to establish the right. You own a house. You have the papers in your name. That's your property. So anybody transgressing or taking that property by force, you go to the court and say, this is my property. This is how the property dispute cases that you may have seen in your families, in the neighborhood, in the friends, that is how then you need to establish the claim that what I'm claiming is right, and the documentation helps. So that's another kind of a right. Fundamental rights are always guaranteed by the Constitution of each state. So fundamental rights are very much enshrined in the Constitution of every state. A little bit of history, and this is the codified history. If you go before that, and we will also go there, that historically the laws were already there in the religious textbooks, in Mahabharata, in Bible, in Quran. So you have the rights. And I will go in details in some of the rights which Islam has guaranteed, that how Islam completed the definition of the rights. The definitions which were rather incomplete or insufficient in other texts, how Islam made it a complete circle. So Magna Carta, 1215, this was a document which constitutionally defined some rights. Then the Bill of Rights, 1689, the French Declaration of Rights of Citizens, Universal Declaration of Human Rights, International Covenant on Civil and Political Rights, EU Charter of Fundamental Rights. So these are some of the international instruments that you may visit and see that what kind of rights they are talking about. So there are civil rights, there are political rights, there are fundamental rights, there are human rights, and some of the rights are universal. What do you understand when we say there are some rights and those rights are universal? It's universality of the concept, that it is not related to one religion, one caste, one country, or one nation. It is universally accepted. Everybody agrees to the concept that there are certain rights which are universal in character. Right to life, right to liberty, right to movement. There are certain rights. But then within those rights can be taken away by certain legal actions. So if somebody is put to the gallows, the right to life is taken away. But that's a legit source, because somebody has done something where the punishment was defined, that the punishment will be given, will be a death punishment, and when he or she goes to the gallows, then that universal concept of right to life, so there is always a parallel regime. But broadly speaking, universal rights are those which every nation, every constitution, they have agreed upon that these should not be taken arbitrarily. They cannot be taken illegally. You cannot use law, an excessive form, to take someone's rights which are universally accepted. Magna Carta, this is the first ever codified charter of fundamental rights under the Western law. Law is always, remember, and as a lawyer I will defend law, that there are no discrepancies in law. It is the interpretation of the law and certain administrative actions, and we will come to that. And we will have discussion on this, that when is the time when the law, instead of coming to your security, adds to your insecurity. And that is what this forum should be discussing, right? So Magna Carta, the first ever codified. By codified document, we mean that there was an existing concept, but a scattered one, right? Like if this audience talks about different issues during these 3 days, right? And then at the end of the day, there is a declaration issued by this house, and which is written and agreed by all. So we will call that document a codified document, that the ideas were scattered in everyone's brain. They collected the ideas, they agreed upon one document, and when they produced that document, that is a codified document of this house. So this is codification. So the laws were present, as you mentioned, in different religion, in different texts, but then when it became and shrinked into one document, it became a codified form of the laws. So Bill of Rights consolidated and enacted all essential rights and liberties of every citizen. We will also be distinguishing between all persons, all individuals, all citizens. So while reading some laws, you will see all persons. That includes men and women. All individual, that includes all men and women. All citizens. Then it means that the law has a restriction bar. that it is only speaking for the citizens. French Declaration guaranteed the basic human rights, Universal Declaration of Human Rights. Now, if you look at the progress and the history, so there has been a huge gap between 1215 and 1689 and 1789, like almost 100 years, 200-300 years, and then in 1948. So a lot of discussions took place, I assume, that during all these years. So people were talking about these rights. International Covenant on Civil and Political Rights, famously called ICCPR, International Covenant that ensures security of civil and political rights. So if you look at the timing, the Second World War ended, the Cold War era, and then people are talking about more rights for themselves, and this is how the International Covenant came into being, to protect individuals from unwarranted government action and ensure an individual's ability to participate in civil and political life of the state without discrimination or repression. So this was also considered a right, that if somebody, a citizen, wants to participate in civil and political activities of a country or a state, he or she must not be hindered. So this was an internationally agreed principle. But when you come to the national legislations, then there might be some restrictions. There is one restriction on one of the most decorated position in Pakistan, which is the office of the President of Pakistan. There is a restriction. Can somebody tell me that restriction? He must be a Muslim. So that's a restrictive clause. So if you look at this, that all citizens, all individuals, but then there comes a restrictive clause. Why? We will discuss that why there are certain restrictive clauses. The EU Charter of Fundamental Rights enshrines equal political, social, and economic rights for all citizens and residents of the EU under EU law. So now it is becoming more of a regional legal instrument. So there are certain instruments which are universal. The Human Rights Declaration, it goes for all human beings. These ones then again come with the regional restrictive clauses, that only those who belong to the EU states. The EU CFR was given a binding effect over all EU member states by the way of Treaty of Lisbon 2009. There are certain declarations. If the Committee of States get together and issue a declaration, so declaration is not a binding force. It is not important for the states to follow it in letter and spirit, because they only set the guidelines. And then the international treaties demand that the national legislations should take place. There should be a national mechanism to translate those international instruments into their national legislation. So they are only the guiding principles. But most of the nations, and from the Forum of the United Nations, it is the states are encouraged to practice and follow the declarations. But then you have treaties. They are binding. When you enter into a treaty, that's a binding force. You need to comply with those legal instructions. Long before the Magna Carta, Islam guaranteed all the fundamental rights of human beings, such as the right to life, equality of all, freedom of religion, trade, right to privacy, equal protection and dignity. And the sermon of the Holy Prophet, peace be upon him, 7th March 632, on the occasion of Hajj, serves as the charter of fundamental rights for all humankinds, irrespective of any discrimination. किसी अरबी को अजमी पर फौकियत हासिल नहीं होगी. So that set the tone for the Islamic characteristics of the Constitution. So that can be referred as the main document that one can refer to and seek guidance from. Fundamental rights in Islam, other landmark documents providing for the fundamental rights of all citizens, the second Caliph Hazrat Umar's Charter for Jerusalem, Khalid bin Walid's Charter of Liberty. If I'm not wrong, there is still in Norway a law called Umar law. Do you know what that law is? In a foreign country, there is a law called Umar's law. That is basically, the story goes back when Hazrat Umar was the Caliph and he had some restrictions on the purchases of the commodities, and when he was crossing a house at night on his regular recce as an administrator, so he heard a baby crying. So he inquired and he came to know that because of his restriction, the mother was unable to buy the milk from the market. So then he announced that all the babies should get free milk from the state. So that's why in certain countries, in European countries, you get money if you have infants to feed them. So that is coming from the Umar law. So the Norway government has still kept that name, that since it originated with Hazrat Umar, so the law is called Umar. That is again a basic right, a human right. Fundamental rights in Pakistan. Now we have discussed a little bit of what happens outside Pakistan, what happened historically. Now we will be coming slowly to Pakistan. The Objective Resolution of 1949, an extremely important document when it comes to the legal debate in Pakistan. Come what may, you will come across this document, you like it or you don't. The Objectives Resolution. The first ever constitutional document after the creation of Pakistan which provides guidelines for the future of Constitution of Pakistan should look like. It provides for basic civil, political and economic rights of all citizens, irrespective of their gender, religion, ethnicity and financial status. It provides that democracy, freedom, equality, tolerance and social justice according to the principles of Islam shall be the basic features of the future constitution. So these were the basic fundamental guiding principles that the objective resolutions agreed upon. And the word used is all citizens. So it means the citizens of Pakistan. But since there was no constitution at that time, so the definition of a citizen, that who will be the citizen of Pakistan, only came in the year 1951. So after almost 5 years of the creation of Pakistan, the definition of citizen came into being. Why? So Pakistan was created in the name of Islam. We all know, right? Pakistan ka matlab kya, right? So everybody who was a Muslim living anywhere in the world, they said that Pakistan can be our country because it is taken in the name of Islam. So any Muslim can be a citizen of Pakistan. And the Muhajir movement to Karachi, because Karachi was the capital then. So there were people coming and claiming the citizenship. So that's why, to put a stop that no, we didn't really mean that every Muslim should be a citizen of the country, we should be more clear about it. So the Citizenship Act of 1951 came into being, and that defined who can become a citizen of the country. Now, having said this, Pakistan is a highly, highly complicated country when it comes to the legal regime. It's one of the most complicated countries in the world, and as a lawyer, I am saying this. Now, Pakistan is a patriarchal society. Unlike Bangladesh, that's a matriarchal society. That's why you may wonder, Hasina Wajid and the other Prime Minister, Sheikh Hasina Wajid and Khalda Zia, why they are the female head of the political parties, because Bangladesh is a matriarchal society. It goes with the name of the mother. Pakistan goes with the name of the father. So it's a patriarchal society. So that means that if a Pakistani a male produces children, so those children will have the right to be the nationals of Pakistan. But if they are born to a woman who is a Pakistani but married to a non-Pakistani, the children will not get citizenship. Now, this is in direct contradiction to the Islamic principles of men and women are equal. So that's why till date the Shariat court decision to challenge the very character of a patriarchal society when it comes to the births has still not given the judgment. So that needs to be settled. So that could be one of your research topics. And at the same time, then adding to the birth. So section 4 says any person born in the territory of Pakistan shall be a citizen of Pakistan with 2 exceptions. Diplomats immune to the law, because when you are a diplomat, so you are representing another country, so if you are residing in a country, that doesn't mean that you become part of that country. So the diplomats immune to the law, if children born to the diplomats in the territory of Pakistan falls in that exception. And then the citizens or the nationals of an enemy state declared by the state. Now, another question that might come to your minds is the Biharis, the Bengalis, the Rohingyas, the Afghans. 4th generation of Afghan is living here in Pakistan. 3 generations are born in Pakistan. Are they citizens? Documented 1.4 million, undocumented equal number, unchecked more. Well, I will be talking more on the legal grounds. The UN charters, they do not guarantee the rights of the citizens within the country. You cannot take their life. You cannot subject them to torture, right? But you can restrict their movement. Iran has done it for almost 40 years. Yes, that's called the right of the people when they find themselves, and that's Article 1 of the Refugee Convention that defines who can become a refugee. Because you have a refugee, then you have asylum seekers, then you have economic migrants. There are various categories. So for a refugee, there are 5 fundamental standards set by the international law, that he or she must have a fear of persecution based on race, nationality, ethnicity, political opinion, and have a fear of persecution. So the fundamental is that there is a fear that they will be persecuted in that country. So when they move to the neighbor countries and want to cross the border, the international law demands that the borders should not be blocked. Why? Because it will be in direct clash with the codified law's right to life. So if the right to life is in danger, the borders should be opened. Once they step into another country, they become the refugees. So for a refugee, the condition is that you must cross the border of one country and go into another country. Then there could be mass refugee influx, thousands coming in, and then there could be one refugee, one family coming in, because then the law also says the refugee status determination interviews, RSDs. So the RSDs are conducted in different countries by the immigration department and the refugee departments. So they make you sit and they say, like, what's your problem? If the political situation is not known to the world. The forceful return is called the voluntary repatriation. That the repatriate means going back to exactly the position from where you came. That's the condition. So if from Afghanistan, when you left Afghanistan in 1979 after the Soviet invasion from Nangarhar, so the repatriation principle demands that you go back to Nangarhar, and that repatriation must be voluntary. And voluntary, we all know that it's your own will that you want to go. We can discuss that. Next, please. The fundamental rights in Pakistan, the Constitution of Pakistan, 1973. Fundamental rights बहुत मखसूस हैं, जैसे right to life, right to, and then I will be explaining कि right to life के अंदर कितने basic rights हैं. और basic rights तो एक नॉर्मल टर्मिनोलॉजी है, एक स्लैंग है फंडामेंटल राइट्स की, जी ये तो मेरा बेसिक राइट है, अदरवाइज द लीगल वर्ड इज द फंडामेंटल राइट. अब उसकी तरफ हम आते हैं कि कुछ चीज़ें ऐसी हैं कि जो फंडामेंटल राइट नहीं है, वो स्टेट इम्पोज कर सकता है. आपने कभी दफ़ा 144 का नाम सुना? बहुत सुना है ना. अच्छा, दफ़ा 144 किस चीज़ को चैलेंज करता है? राइट टू असेंबली को. अब ये एक बहुत इंपॉर्टेंट राइट है कि अब ये असेंबली है, राइट, वी ऑल हैव असेंबल्ड हियर. अगर यहां पर एक पाकिस्तान लॉ इन्फोर्समेंट एजेंसी का बंदा आके खड़ा हो जाए और वो कहे आप क्या कर रहे हैं, आप शाबाश चारे जाए, जहां से आए आप वापस जाएं, आपका रिस्पॉन्स क्या होगा? ऑर्गेनाइजर्स का क्या होगा कि व्हाट इज योर प्रॉब्लम? नहीं, क्या मतलब, कैसे जा सकते हैं, वजह क्या है? ठीक है. लेकिन अगर एक होटल एडमिनिस्ट्रेटर इस वक्त आ जाए और उसके हाथ में वो आग वाली वो एक्सटिंग्विशर हो और आपसे कहे निकलें, जल्दी निकले, जल्दी निकले, और हमें सबको निकाल ले बाहर, इसको क्या कहेंगे? इवैक्यूएशन, हाउस ऑन फायर. बिकॉज the hotel management thought that there is some danger to our lives, so we can be evacuated, and not in a very humane manner as well. लेकिन वो लीगल एक्शन होगा. लेकिन अगर कोई आपको जबरदस्ती निकाले, वो इलीगल होगा. So you have to really, as a lawyer, we have to look at things at the very details. ये जो जर्नल स्टेटमेंट्स होती हैं ना, ये अखबारों के लिए है. जैसे आई रिमेंबर एक दफ़ा इलेक्शन थे, आई डोंट नो विच ईयर्स इलेक्शन, लेकिन हमारे हुए ही कम हैं, सो वन ऑफ द इलेक्शंस, उसमें कहा कि तीर टूट गए, दिए बुझ गए, शेर छा गया. अब who on earth other than a Pakistani with political knowledge would understand this? लेकिन हम तो समझ गए. तो कुछ चीजें होती है समझने के लिए. That is the role of the journalist, to create sensational stories, to add emotion to it. Law is the subtraction of both. ना इसमें emotion है, ना इसमें sensationalism है. अगर कोई औरत कोर्ट्स में जाके 2 घंटे रोए, तो क्या मुमकिन है कि बगैर आर्गुमेंट के उसका केस उसके हक में हो जाए? द जज वुड बी सिटिंग वॉचिंग एंड सेइंग, बीबी मत रोएं, बताएं क्या इशू है, आप ना करें ऐसा. बिकॉज इमोशन हैज वेरी लिटिल रूम व्हेन इट कम्स टू लॉ. नाउ the Constitution of Pakistan, this document incorporates the objective resolution as part of the Constitution under Article 2A. So हुआ क्या कि the objective resolution of 1949 became part of the 1973 Constitution. और उसमें कहा गया कि कुछ चीजों को आप बदल ही नहीं सकते. फेडरलिज्म, इस्लामिक कैरेक्टर, ठीक, and there are 2 others, fundamental rights, or there is one more, I'm forgetting, कि ये 2-4 चीज़ें जो हैं इनको आप कुछ नहीं कर सकते, बाकी लॉस चेंज हो सकती हैं. That is why when we say the President of Pakistan has to be a Muslim, because the head of the state in the Islamic state must be a Muslim. Prime Minister के लिए नहीं है. because Prime Minister is not the head of the state. The Prime Minister is the head of the government. ठीक? The preamble of the Constitution of Pakistan provides that freedom, equality, tolerance, social justice, freedom of religion, equality of status, freedom of thought, expression, faith, worship, association, public morality, and belief shall be the cardinal principles for the social and political structure of Pakistan. अब ये सारी चीज़ें अगर देखें तो ऑब्जेक्टिव रेजोल्यूशन से पहले भी in the sermons of the founder of the nation. So these were the standards derived and influenced from the Islamic character of the country. Because the fundamental rights defined in Islam are the most sophisticated till date. Like no one can challenge the magnanimity of the rights enshrined in Islam. There is no document. If you pick up every document, and I give you examples, that the modern jurists of today, they have not defined unnecessary sufferings in war. It was the napalm bomb in the Vietnam War where the Time magazine showed a 16-year-old girl naked running with a fire on her back. It halted the war, this one photo. And they say there are few photos in the world that changed the history of the times. Remember the African famine where the vulture is sitting next to the baby, waiting that the baby dies, and yes, that photo. The Syrian boy, shores of the Mediterranean. The Afghan girl, the green-eyed, Sharbat Gula, the National Geographic. These are some of the images that changed the history of the events. But till date, the international jurists have not been able to define unnecessary suffering. This is something which is directly related to the international conflict situation. It's a war law terminology. That you can use power, but that power must be used in a way that it does not contribute to unnecessary sufferings. Now the law is there, but the law is left to the interpretation of the military commanders. What constitutes unnecessary suffering? So they say, well, nuclear weapons is an unnecessary suffering because for a very long time, where it is used, people will have the effects. So it's unnecessary suffering. If you can kill somebody with a bullet in a war, the war does not stop you to fight and kill somebody. So that's not unnecessary suffering. But bombing civilian villages, killing children, that's unnecessary suffering. But still it is not very much defined, and as an interest in international law, I always thought that there has to be a definition. Like it can't be like you can't explain unnecessary suffering. And then I stumbled on the Islamic definition of unnecessary suffering. And that was also coming from, there are two concepts in the Islamic law. One is called Jawazul Harb, the reasons of war. That before you go to the war, you should qualify Jawazul Harb. You should qualify the reasons why you are going to war. It does not say you cannot go to war. It says Jawazul Harb. And the second principle along with Jawazul Harb is Adabul Qital, the decency in killings. So again, it does not prohibit killings in war. So I'm talking of the Islamic conflict laws. And the modern laws have translated these terminologies as jus id bellum, how to go to war, right? And jus in bello, how to act in war. So the jus id bellum mandate rests with the United Nations, where the Security Council gets together and announce a war against another country. So that mandate is given by the Committee of the States to the United Nations, to the security, through the security resolutions. And I found a definition that during a war, when you are using an arrow, the tip of the arrow must not be dipped in poison, because that poison will generate unnecessary suffering. So anything, any weapon that has the capability, and you have, like the weapon is known for an action, that action should not be amplified with something else, because that will constitute unnecessary suffering. As a lawyer, I thought that's a beautiful way of getting into the details. The international law has defined children, not infants. Islam has defined infants as well. That yes, please. Islam says that do not kill those who do not fight those who do not fight against you. Surah Baqarah. Mat lado unse jo nahi ladte tumse. So the standard is very clear. The international law says, Akhdi Kamba, do not fight those who no longer participate in hostilities. So the Islamic principle, mat lado unse jo nahi ladte tumse. So that is very clear. If the woman participates in hostilities, she becomes a combatant. But the children can't.
So your point, unnecessary suffering after the war. So we can't hurt the women and the children.
Yeah, I agree. No, I didn't say, I said like the international lawyers were unable to define the details of unnecessary suffering. The word is there. But what constitutes unnecessary suffering? That is limited in international law. The Islamic principle added to it that if you are using a weapon that has already a capacity to hurt you, so in wartime, if the arrow hits you and injures you, you won't die out of that injury. But if there is poison to it, so it will add to your miseries. So that is where the details come in as a lawyer, I'm thinking. Yes, please. I would say that wars, legality and the not legality or the illegality of the laws, that goes ages back, because humans, Habil, Kabil, the elements of this is mine, this is yours concept will always remain. We cannot challenge the very fundamental ingredients of a human being. Because of instincts, because of something that we humans have always enjoyed the superiority. And we always liked to be in a superior position from others. That's a very characteristic of the human being. And I was reading once that when God Almighty got bored with the over-dutiful angels, then he decided to create a creation with the faculty of saying no. So that is how the humans were created. So God knew what he is creating. And that is why the two essential elements of the beings is in the human being, which is the Ashraf al-Makhlukat, the best of the best among all the beings, and the worse is Asful Safilin, the worst of the animals. So these two characteristics, it's within us. So if we decide to be Ashraf al-Makhlukat, the ingredients are there. But if you choose to be Asful Safilin, the ingredients are there. And that is what makes us different from angels. The kinds of fundamental rights, social rights, political rights, cultural rights, economic rights, these are some of the fundamental rights. मेरा एक culture है, उसको preserve करना चाहिए. I will practice my culture. So I am a Pashtun. So we say that the word Pashtun is made of 5 words, and each word refers to a characteristic. So they say pe, khe, te, waw, nun, Pashtun. So pe means pat, to keep a grudge. Khi means khegada, to do good. Ti means tura, to have a sword, fighting characteristic. Waw, wafa, loyal. Nun, nang, to die over honor. So they say if these 5 characteristics does not qualify in a person, he's not a Pashtun. Right? And then you have the cultural ingredients. Milmastya, hospitality. In a Pashtun culture, if you happen to be a guest of somebody and you are on diet, you are a dead man. They will make you feed to death. The more you refuse, the more they will fill. So now that is culture. And the culture is all around the world. You have Hindu culture, you have Christian culture, you have Buddhist culture, you have cultures all around the world. And that is why the international law says that if you don't find anything in the international instruments, refer to the customary laws, because the customary laws will have something which can answer your question. As per Article 4 of our Constitution, the social rights, all individuals are to be dealt with in accordance to the law and are entitled to equal protection under the law. So that's Constitution, that's Article 4. No person shall be deprived of and no action detrimental to life, liberty, reputation or property of any person shall be taken except in accordance with the law. Now the comma in the legal language shall be considered an important character, because in English, comma means you take a break, right? The semicolon, the colon. Full stop, the very word means full stop, like stop. So you make a break. So when you are reading the legal texts, please do not ignore the commas, the colons, the semicolons, and the full stop. And when there is a comma, you will always see an exception clause to the next, the line. And at times in law, I tell my friends that we have almost everything in the law. So if I want to be defamatory with somebody, but in a nice way, so I can say, he's my very good friend. He never stole my watch. So what are you doing is, you are adding a negative character to somebody's introduction. So this is called innuendo, that when you add a negative line to somebody's introduction. So the other person might take it as defamation, that why you are associating me with stealing my watch. So that's prohibited, right? That's not permissible. No person shall be prevented from or hindered in doing that which is not prohibited by law. That somehow comes under your question, that no person shall be prevented from or hindered in doing that which is not prohibited by law. So if it is not prohibited by law, you can do it, but if it is prohibited. Now for the foreigners, they say that the foreigners can drink in a public place where in hotel the room, they cannot drink in a public place where in a hotel lobby is a public place, room is not. So gives a criteria that the foreigners can drink. So that's why in major hotels you will find bars for foreigners. So there has to be a designated place. No person shall be compelled to do that which the law does not require them to do. So nobody should be subjected to something which the law does not ask them to do or demands them to do. So this is Article 4. These are the social rights. No person shall be deprived of life or liberty save in accordance with the law. The chapter 1 of our Constitution is phenomenal. I would recommend read that chapter as a pleasure reading, and you will feel very good about Pakistan. You'll say that, well, we can compete with any country in the world when it comes to the rights. And I said pleasure reading. In the case of Shaila Zia, PLD, Pakistan Law Digest, this is how we define the cases when you want to refer to a case, when the case is documented, so it comes as either SCMR, Supreme Court Manual Review, or the PLD Pakistan Law Digest. So the number of year, that which year the decision was, which court was issuing the directive, Supreme Court, page number 693. So this is a documented case. The Supreme Court held that the term life includes standard of living and quality of life. The Supreme Court went on to state that it is the responsibility of the state to ensure a reasonable standard of living for all citizens. So Ms. Shala Zia, resident of Islamabad, there was a grid station next to her house, and she filed a petition. She said that the magnetic waves coming out of the grid is dangerous for us as a family. So I have a house here. Why they created a grid station next to my house? So the Supreme Court ordered to remove the grid station and said that the right to life should not be taken as that you can take the life or not take the life, but the quality of life. So if you see a danger which is affecting your life, so the expansion of the right to life was introduced. And always remember that the law is interpreted and the scope is expanded only through when the citizen of the country take the dispute to the court. If you don't take cases to the court, the interpretation will never take place. The expansion of the law will never take place, because this is how interpretation takes place. So the right to life in 1994, after 1973, 1994, the right to life was questioned by a citizen, that this is a danger. So this, the grid station was removed. And grid station is a big thing. Like, it's not like a generator that somebody removed. So it was a grid station. In the case of Pir Imran Sajid versus TIP, the Telephone Industries of Pakistan, the headquarters are in Haripur. So that was 2015 SCMR. The Supreme Court held that the right to life as envisaged under the Article 9 of the Constitution includes the right to livelihood, good governance, social justice and job security. So he was removed from the services, and he thought that the grounds were not correct. And the Supreme Court expanded the definition that right to life means livelihood. So if I tell you you have the right to life but you have no right to eat, so you will starve to death. That's not the right to life. So that is the interpretation which the Supreme Court added, that right to life does not mean that you only say that there is right to life. But the essential ingredients that constitute what right to life means should be incorporated in the decisions. No person shall be arrested or detained without being informed of the charge, without being given opportunity of legal assistance, and without operation of law. That is again a fundamental right. You cannot be detained unless and until there are legal reasons. In case of Asma Jailani, PLD 1972, Supreme Court, page 139, the Supreme Court of Pakistan elaborated on the principle and went on to declare that the operation of law means that the law should be validly enacted and not ultra vires of the principles enshrined in Article 8 of the Constitution. So Ghulam Jailani, her father, was an activist, a Democrat in times of the civil martial law administrator Z.A. Bhutto's time. So he was detained, along with Mujib Shami's father. Mujib Shami's father was a writer, he was a Democrat, so he was put behind the bars, he was detained. And when there was an interim constitutional order by the civil administrator, the martial law, we had only one civil martial law administrator in the history, Zulfikar Ali Bhutto. So when the martial law regime was ended, so the because then the constitution came back, the interim constitution was there. So Asma Jailani filed a case that this was illegal detention. And then the Supreme Court held that yes, nothing can go against Article 8, which says, like, you cannot be detained, you cannot do any action against what is enshrined in the Constitution. The law of preventive detention is, however, exception to the general rule. See how many commas are there. The law of preventive detention is, however, comma, exception to the general rule. So the general rule is you cannot be detained other than for legal reasons. But then there is a preventive detention. The Americans have used it a lot after 9/11. You fear that somebody would do something, so you go for preventive detention. That before he does it, because we have sufficient grounds to believe that this individual is capable of doing something which would be illegal, so we go for preventive detention. Before he does it, we have prevented him in the best interest of the state. Now, if there is a clash between an individual right and a public right, which right shall prevail? Public right. Why? Greater interest, right? Now, I have a house on M2 back in 1990s, and the government comes, and that's an ancestral property. I have my emotions to it. My great-grandfather lived there, and now the government comes, take the money, we bulldoze the house. But we said, like, right to property, if I own it, that's my right. But the state comes and say we are bulldozing it. How many of you thinks it's against the law?
Can I add something?
Yeah.
Ask a question about it?
No, first let us settle this dispute. Only one person thinks that it's illegal. The rest you think it's legal. How would you define, how would you justify it? That's right. It is legal. Now, anything which you see illegal in first instance, so if I give you half information, that, oh my God, my house was bulldozed by the state, the journalist would make a story out of it. Because they have not read after the comma that it was in the interest, a larger interest. When the state destroys the mosque, what is the terminology which is used? कहते मस्जिद को शहीद किया गया. So then you take the masjid to another place. It's a permissible act. So when it comes to the state necessities, the individual rights become Mickey Mouse. Very small. Somewhere you cannot even notice them. Because it's a state responsibility, it's a state interest. So whenever you see something like which does not comprehend, always think that what is that is making it happen. So when you know that picture, then you say, okay. Like taking millions of people out of FATA and SWAT for military operations, becoming IDPs, it was in direct conflict with right to life, right to freedom, right to have a dignified living. Whatever kind of a house you have, we all have a dignified place in that house, whether it's a mud house or it's a mansion. So the dignity comes within those four walls. Beyond those four walls, the dignity is compromised. So in the camps, forget it, just because by the sheer number of people. If one kind of food is cooked, you like it or you don't, you feed yourself. The parda, women, children. So that's something which was discussed in the landmark judgment. In the case of Anisa Rahman, 1994, the Supreme Court held that the principle of adi altrum partem, let the other side be heard as well. So this was established under the law by the judgment that the principle of adi altrum partem must be the part of the decision. And this was again would be applicable not only to judicial but also to non-judicial and executive proceedings. So what was added new to the law was the principle of the application to non-judicial and executive proceedings. She was removed from a job. And then she said that she was not informed, she was not in picture. So the Supreme Court then interpreted that the other side to be heard, because courts do that. So they said it's not only the judicial proceedings, they are to the non-judicial and the executive proceedings as well. So this was something new added to the law. As per Article 11, slavery, human trafficking and forced labor are prohibited. No child below the age of 14 years shall be engaged in any factory, mine or other hazardous employment, exception compulsory services, punishments and public purposes. Again, there is an exception. So if you see the young cadets on the mountains of next to PMA running with 25 kg of weight on their back and running and gasping, so that's not forced labor. That's the requirement of the training. So that's basically. Then punishments. So if you have done something wrong and you are subjected to the punishment and you say you can't give me punishment because it is against the constitution, so they say there is an exception. So for the compulsory or public purpose. Now what comes to your mind when we say that it can be seen as a forced dangerous labor, but when it is for the public purpose, what comes to your mind? It was never justified by any regime of law. Child soldiers, child combatants is prohibited. Like there is no explanation to it. One cannot justify. But has it happened? Of course it has happened. Somalians, the Janjaweeds, the Chechens, everybody has used child soldiers. But my question is that for what public purpose, when you see somebody in a forced labor or a dangerous environment, but it is for public purpose, any kind of danger. Like for example, in normal circumstances, if you tell me कि ये नौशहरा का जो दरिया है, इस पे आप ये टूटी फूटी सी कश्ती है, शायद आपको पार लगा दे, शायद ना लगा दे, आप इसमें बैठे और सैर करें. So let me finish. Will that, and if somebody subjects you to that, कि नहीं आपने अभी आप आए हैं फिश खा के जाएंगे और आप इसी कश्ती में बैठ के आपको मैं सैर कराऊंगा, it would be subjected you to torture. कि एक तरफ आप बता रहे हैं कि शायद ये गिर जाए, शायद पहुंचे ना पहुंचे, लेकिन आप चूंकि हमारे मेहमान हैं तो जाएंगे तो आप जरूर. And there is a true history about it. I will tell you on a lighter note after this. But in times of flood, in times of earthquakes, natural disasters, you must have seen hundreds of people risking their lives for a greater public purpose. So if there is a flood, you would give a damn कि शायद पहुंच जाऊं कश्ती पे, because maybe on the next side is your family. Greater public purpose. I have served both in the 2005 earthquake and 2010 and 11 floods. The nature of work, when you call it a humanitarian work, when you go, you don't realize when this roof is going to collapse, but you stay there. So that's a greater public good. So that is dangerous for you. Like you should not be subjected to something dangerous. But then there are times when so as a civilian, you will be restricted. Like for example, a Marriott bombing. As a civilian, you could not just go in. There were tapes and they would say like, you know, take a side. Even the employees were taken out. So when the state can control a situation where the state, because this is the monopoly of the state to control the state. So if you are not a state, you are a citizen of a state and you are not mandated to be present, so the law can stop you. You cannot claim it as your right that, oh my God, Marriott bombing, when it will happen again, I need to see inside.
As a volunteer, sir, there are organizations.
If needed, that is based on the need basis. In earthquake and in floods, the magnitude of the disaster was such that everybody was welcomed. So you would see trucks of food coming in, people coming in. Muzaffarabad, that was less or very little frequented by the foreigners, was flooded with the foreigners. So you put halt to your normal operations. When you say that, I can't handle it, when the state admits that I cannot handle this kind of a disaster, so then you can. As per Article 12, every person shall enjoy protection against retrospective punishment. So if there is a law in place which came into being, all the laws, they do not go into retrospective except one law in Pakistan, which is the inheritance law. So if the father dies, what is the share of the daughters and the sons? So that's the only law which can go back into retrospective. The other laws are not in. You cannot punish somebody when there was no law and the act was committed and you go back and then you ask for the rights. As per Article 13, no person shall be prosecuted or punished for the same offense more than once. No person shall be compelled to become a witness against himself. Right? This is law. I cannot force you to be a witness against yourself. So that would constitute what? Forced confession. Zabardasti. So that's why the police confessions are not admissible in the court of law. So anything stated in front of the police is not admissible in the court of law. The magistrate, the confession has their own rules and procedures. Sorry for pinpointing my colleague who has been a judge for 15 years. He just entered, so I will transfer this question to him. If somebody does not want to become a witness but is witness to something which is, so will it be an obstruction in the way of law?
That is not right. If once you are ready to become a witness, then you are bound to be a truthful witness. If you then, so you have to be a true witness. And if you give false evidence, then the Pakistan Penal Code Section 192 of Pakistan Penal Code that provides punishment for such person.
So thank you very much. This could only come from a judge, not from me. Okay, next please. As per Article 14, the dignity of every person subject to law and the privacy of home shall be inviolable. No person shall be subjected to torture for the purpose of extracting evidence. So that's similar to what Mohsin Saab just mentioned. Next please. As per Article 15, every citizen subject to reasonable restrictions imposed by law in public interest shall have the right to reside, settle and move wherever in Pakistan. In the case of Federation of Pakistan versus General Pervez Musharraf, the Supreme Court held that the right cannot be abridged or denied arbitrarily on mere liking or disliking without any lawful justification for this purpose. So if somebody is not convicted yet, his or her movement cannot be restricted. If another country is willing to accept that person, so another country willing to accept that person, what would be the guarantee? The passport and the visa. Article 16, freedom of assembly, freedom of association, freedom of trade, profession and business, and freedom of speech. So these are 16, 17, 18, 19. Freedom of speech, I will pick on one. There is a recent Supreme Court judgment that freedom of speech does not mean that you can say whatever you want to say. And you all would know that why Supreme Court was forced to give this judgment. अगर वो hate speech constitute नहीं करता, अगर वो किसी और के rights violate नहीं करता, so that comes under Article 19 of the Constitution, freedom of speech, कि ये आपका हक है कि आप लिखे भी, आप film भी बनाएं, आप documentary भी बनाएं, with a condition that it should not go beyond the parameters of disrespecting someone else. The moment you cross that line, it comes under the heading of hate speech. Hate speech is a new phenomena और इसको अभी सुप्रीम कोर्ट ने बहुत elaborate किया और कल की खबर मैं पढ़ रहा था कि सुप्रीम कोर्ट has called Senator Abidi and asked for an unconditional apology from the owner of the television, and the anchor who took the interview is out of job as we are speaking now. क्योंकि Supreme Court said that it was an abusive, excessive language. So the abusive word is added after the Faizabad Dharna, that you cannot abuse the state institutions. So this is how the freedom, so there is limitation to the freedom of speech, and I will explain. Next please. Right to information, again something which is a fundamental right, In the case of Hamid Mir 2013, the Supreme Court held that all public offices are bound to disclose information of public importance. कुछ प्रोविंसेस में राइट टू इन्फॉर्मेशन बिल भी आया है. हामिद मीर ने केस किया कि इंफॉर्मेशन मिनिस्ट्री ने कुछ प्रोक्योरमेंट करनी थी जो कि एम्बेजल्ड हुए, अब वो हमें बता नहीं रहे. सो देन द मिनिस्ट्री ऑफ इंफॉर्मेशन प्रोवाइडेड ऑल द इंफॉर्मेशन टू द सुप्रीम कोर्ट दैट द स्टेट इंस्टीट्यूशंस मस्ट give details if the citizens want to have if they would like to know. So as a journalist, you have the right to go and let me quickly finish and then I give time to the questions. Freedom of religion, every citizen has the right to profess, practice and propagate their religion and establish their religious institutions. बहुत से प्रोग्राम आपने देखे होंगे इंटरफेथ हार्मनी के, the Hindus celebrating Holi, the Christians celebrating Christmas. These iconic figures that you see in newspaper and TV clippings, ये कोई random चीज़ नहीं हो रही. In order to provide a platform that there are actions taken under the constitution, कि constitution कहता है कि everybody is free to go to the mosque and to the places of their worship. So अगर वो नहीं होता तज़ाद में, so by having a ministry, a religious ministry doing interfaith programs, so it is not just for the public consumption, it is basically to let the public know and let the state so that they can practice that we are following the law. Safeguard against taxation for purpose of any particular religion, safeguard as to educational institution in respect of religion. That's why we have the madaris, because if it's Islam, so they have a religious institution. By the way, we have three kinds of educational setups, public, private and madaris in the country. Subject to reasonable restrictions, the right to acquire, hold and dispose of property anywhere in Pakistan. Again, as a citizen, you can go and enter into a transaction to buy property anywhere in Pakistan. Next, please. Article 25, all citizens are equal before law and are entitled to equal protection of law. There shall be no discrimination on the basis of sex. Nevertheless, the Federation has the privilege to make special provisions for the protection of women and children. For women and children, you have separate laws for the juveniles. So it's when you say of all citizens, it's the women and children are excluded. In the case of Faraj Jalil versus Government of Sindh, the Sindh High Court condemned discrimination on the basis of sex. There was a famous case which was a medical school where 200 seats reserved for men, 200 for female. So the lady was not in the 200 women, so she said that, well, if the college is open for co-education, why further division of merit between men and women? It should be open, and then the case was decided. The state shall provide free and compulsory education to all between 5 to 16. 11.1 million children are still out of school today, so the law is there, but in practice things are a little different. Article 26, no discrimination in respect of access to public places, safe places specified for women and children. कि आप सारी जगह जा सकते हैं, लेकिन अगर ख़वातीन का पार्क है, so don't make yourself feel as a guest to be welcomed. अगर बच्चों का पार्क है, वो बच्चों का है. अगर so there is के freedom है, लेकिन if there are restrictions. Safeguard against discrimination in services, the Constitution provides that there will be no discrimination in respect of any service in Pakistan on the grounds of race, religion, caste, sex, residence, place of birth. So this also sets a stage for against the discrimination in services. The right to preservation and promotion of distinct language, script, culture, I talked about it. Next, please. Political rights, every person above the age of 18 years and enrolled with the ECP has the right to vote irrespective of sex, religion, caste. Subject to qualification and disqualification provided in Article 62 and 63, every person has the right to contest elections. Any one of us, if we qualify, so there is a criteria. Every person has the right to freedom of movement. A person cannot be deprived of his freedom of movement on the basis of his political affiliation, religion, belief and other social contracts. So this is how, if a political party wants to hold a rally, so when they say that it's our right, this is basically Article 15. In the case of Hafiz Saeed, Lahore High Court, and in case of Ayan Ali, the Supreme Court held that restricting the right of movement of any citizen without reasonable cause was not justified. So if people are not convicted, their movement should not be restricted. So these are the two famous cases. Article 17, subject to reasonable restrictions imposed by law in the interest of sovereignty and integrity of Pakistan, public order or morality, every citizen shall have the right to form association or unions. So you are free to form association and unions, but remember it should not go against the state security. In case of Benazir Bhutto, it was held that freedom of association and right to become a member of political party cannot be abridged on the basis of personal likes and dislikes. So between the Zia time, the Zia regime, People's Party was taken to the walls, and even there were martial law orders that somebody who was in this political party from this state to this state cannot participate in elections. So this was contested by Benazir when she came back in 1988 to make the political course legal for herself. Next, please. Article 19, freedom of speech, as I said, but the freedom of speech, Article 19 already has a restrictive clause that, and it answers your question, gentlemen, that imposed by law in interest of Islam, integrity, security and defense of Pakistan, friendly relations with foreign states, public order, decency and morality, that you have freedom of speech, but these things. Now, beyond but, the Supreme Court limitations on freedom came in PLD 2018, which is most recent, in a suo motu petition number 7, that independence of media is guaranteed, but not for the propagation of the commission of offense. That's why the glorification of the terrorist attacks on the TV are banned now. That you cannot basically glorify the commission of the act. Broadcast of hate content, violence, damage and destruction of public property without condemnation. You are happy to show, but you are not going to glorify it but condemn it. So that is again an exception for the broadcasters. Or with intent to justify it was equal to fanning the flame, and such broadcasters were equal perpetrators condemnable under the law. In Quetta case, it happened. So it was response to that as well. Persons carrying violent acts, destructions or damage to public property, abusing or resorting to hate speech, and advocating or propagating these acts are violating the injunctions of Islam. So it is also said in the suo motu directions that you are doing no good to the religion as well. Direction given by the Supreme Court that Pembra Ordinance 2002 section 20C, 33 and 35 should exercise extreme vigilance on media, and if anybody violates, then the aforementioned sections should apply. So Pembra was given a direction that if something happens on the electronic media, these are the sections to be applied. Supreme Court expanded the definition of hate speech by declaring any word spoken or written against state institutions shall amount to hate speech or use of abusive language. This, in coming days and time, I see the inclusion of the abusive language to be challenged by certain people. Otherwise, if it is taken in letter and spirit, we all will be visiting jails one day. Fundamental rights are not absolute and may be taken if the law or circumstances call for such. In accordance to Article 232, 233 and 234, when a state of emergency is proclaimed by the President of Pakistan due to war or internal disturbances, fundamental rights may be suspended. Not the absolute right to life, but right to movement, right to assemblies, those kind of rights. In case of Jabendra Kishore versus Province of East Pakistan, the Supreme Court held that no right can be properly described as fundamental if the legislature can take it away by a law not involving an amendment of the Constitution, or unless its suspension or surrender in the national emergency is specifically provided by the Constitution itself, that certain circumstances does allow actions that normally are not in practice. In the case of Province of East Pakistan versus Mehdi Ali Khan, it was observed that the essential characteristic of fundamental right is that they impose limitations express or implied on public authorities, legislative, executive and judicial, prohibiting them from interfering with their exercise. Fundamental rights are neither indefeasible nor permanent, so that there is a room, there is a chance which they can be taken. Conclusion: it is the responsibility of the state to enforce fundamental rights. So if anybody has any question that who is going to ensure that my fundamental rights are protected, is the state. In the case of Musammat Rohifa versus Federation of Pakistan through Secretary Ministry of Defense, the Supreme Court held that the state, being the guardian of its citizen, was bound to implement the constitutional provisions in letter and spirit, particularly the fundamental rights which were guaranteed by the Constitution. According to Article 8 of the Constitution of 1973, all laws in violation or in derogation of fundamental rights shall be void to the extent of such violations or derogations. A declaration can be obtained by any person from high courts under Article 199, where you go to the high court and say that my fundamental right is not respected. So if you want to go to the high court, it's under Article 199, which are the writs, and the Supreme Court under Article 184 of the Constitution of 1973. A very legit question, and when I say that in coming days I see a lot of things happening after the direction of the Supreme Court, these are the debates which should take place so that the limitations are clearly defined. Because right now, 5 points of National Action Plan indirectly speaks of hate speech. The loudspeaker should not be used for this, the mosque should not be used for this. We need to sit, and you as the profession you belong to, and us and everybody should come together and think about all these legit questions, because the judgment is of 2018, not of 1818. So these are recent discussions that what would constitute a hate speech? What are the limitations? If the Constitution says that it should not prove to be disrespect towards other religions or people, so what would be that disrespect? Because I might be saying things which I think is my fundamental right, because how come the society would progress? But then look at the Western societies, how they have managed it. So learning from the best practices. In London Needle Park, you can go and say whatever you want to say, and most of the time the druggies get on the forum and they start talking, and they talk for hours. So even in the American Constitution, the gerrymandering rule, which was introduced after, because there was no restriction on any member to speak for whatever length he or she wants to speak. So this one gentleman came and talked for 17 hours and producing his bills and the cost that he pays for potatoes in the market. And then everybody thought that no, the freedom is there, but you can't be like sharing your personal utility bills with the audience. Like, yeah. So then the gerrymandering rule came. So we need to have those discussions, that what is the boundary? What is the limitation? Though the directions and certain laws have done their best, but we have to reach that consensus, that what constitutes an abusive language. So I need not to educate this audience that what is an abusive language. So what happens? And this reminds me of, and on a lighter note, that Wali Swat, when he was the ruler of Swat, so he imposed a 5 rupee penalty on anybody who abuses someone else, so that someone else would not abuse in return, but would come to the court and say that Mr. XY has abused, so the court would impose a fine of 5 rupees, which was a huge fine. So once people got bored with this law, so this one person had an urge to abuse the other. So he came to him and in Pashto said that, you are what I think of you. But the shortage of 5 rupees is a problem. So this is how then people started expressing themselves. So we need to define those. We have one collaboration with a government by the name of SurfSafe, which Morango, the organizers, made an excellent clipping, the tutorial for us. There is a new app called Chaucus, which is run by the Ministry of Interior through Nectar. That is where if you see any video, audio, literature material, you report to Chaucus. There is a team which would study that under what law this is a violation, and then it would be given to respective government agencies for penal action. So if it is done by a proscribed organization, it will go to the counter-terrorism department. If it is done by someone else, it goes to the police. If it is a cyber crime, it goes to FIA, and then the prosecution takes place. So there are things in place, but the problem is of awareness. So right now, if you have any material that you would like to share with the government and play a role of a responsible citizen, so there is an app which is administered by the government catering to all the things that, all the rights that I have explained. We don't have a copyright law. That's why we can have a CD in 20 rupees, which the Goras will pay $500 and we can produce any material. We can go to the photocopy shop and do wonders, making like tons of copies, as many as you want. This is against the international law, the Intellectual Property Rights, IPR, and IPR Rule 201, which the US government specifically is trying to implement in the countries and make sanctions. We have a department that looks into the IPR issues, serving bureaucrat heads that office. But since the market is so connected, well connected, and forget about the market, we practice it every day, all of us. If you see, there were no photos in my presentation, right? For every photo in a presentation, you go to the site from where, if it is not your own photo, any photo that you take will be labeled that this was this day so and so, and when you put it on those sites, what do you call those sites where you buy the photos? Shutterstock and another one. There are two. Yes. So why they have put that? Because you go, you purchase. You purchase, then they send you the high resolution. Then you are allowed to use it. Who does it? Even with a shutter thing, we put it on the public place and say, like, look at highly misconduct. But we are, why? Because we are not trained in that way. Stealing someone's intellectual property, we consider it as our inherent right. That what else do you want? I have read your material. If I want to reproduce it, it is my knowledge because I have memorized what you have written. So what about my skills of reproducing what I have reproduced? So give some credit to me as well. That's our cultural issue. Legally, highly wrong. But culturally, it is accepted. Like how many times you may have heard somebody giving a present. I fear the stage when I put a photo and somebody in the audience says that I would not attend your presentation because you are involved in piracy, and walks away. I fear that day. And that would be the day when I would say that the audience is enlightened. They know that what kind of speaker they should be listening to or talking to. Nobody does it. Why? Because they say, बुरी बात है, respect, पता है गलत कर रहा है, लेकिन क्या मतलब करना? Compromise कर लेते हैं, because that's something in culture. So there are issues जिसको आप कहते हैं कि ये जो दड़ादड़ फिल्में बना रहे हैं, स्कूलों में, the teachers would give books to the students and say, copy it. So what should we do? We copy it. That's a wrong. So that's on IPR. There is a department, there is a law, but nobody is ready, and enormous amount of money is involved. If something next to narco, I would say it's the piracy. It's a huge money involved in this. वो अक्सर नई फिल्में अभी तो खैर CDs वगैरह and you can download videos, but the time when there were cassettes, वो सिनेमा जाके वहाँ से करके तो वो जो थर्ड क्लास प्रिंट होता था वो पहले दिन बिक जाता था 25 रुपए में 30 रुपए में, क्योंकि फिल्म नहीं होती थी. फिर ऊपर से दुकानदार बात भी करता था कि ये आधा घंटा लेट हो गई है, इसके 5 रुपए एक्स्ट्रा दें. नो मोर दैट थिंग, बिकॉज आप CDs बनाएं जितनी मर्जी बनाएं. That's a wrong. And we collectively as a nation, we are involved in piracy on daily basis. अगर स्कूल में है तो औरों का लिटरेचर, क्योंकि अभी तो वो HSC ने कुछ पायरेसी वो इम्प्रूव कर दिया है ऑफ थीसिस एंड एवरीथिंग, but there were cases back in 80s and 70s which were opened by the recent administration. All the PhDs, the doctors, the vice chancellors, the head of departments were involved in. अच्छा, अगर सिटीजन वो किसी और कंट्री का है और वहाँ पर एज इमिग्रेंट विजिटर या वो देखें, जब आप अगर डिप्लोमैट नहीं हैं, द रीसेंट केस ऑफ कर्नल एम्यूल or the US embassy who rode on a citizen, ठीक है, वियना कन्वेंशन प्रोटेक्शन देता है और पाकिस्तान डिप्लोमेटिक प्रिविलेजेस एक्ट 1972 टू डिप्लोमैट्स। अगर आप डिप्लोमैट नहीं हैं और आम शहरी हैं, सो देन द लॉ ऑफ द लैंड विल बी एप्लीकेबल। तो अगर वहाँ पे आप क्राइम करते हैं तो आपको वही सज़ा मिलेगी विच इज़ डिपेंडिंग ऑन द नेचर ऑफ द क्राइम, एंड देन the state can decide your deportation as well, कि आपको पकड़ के आपको 2 दिन जेल में रखें, फिर आपकी मिनिस्ट्री के साथ बात करें। और इसके लिए जो एग्रीमेंट EU ने बनाया है और कुछ बायलैटरल एग्रीमेंट्स हुए हैं, दे आर कॉल्ड द री एडमिशन एग्रीमेंट्स, कि आपका शहर अगर वो इलीगल, जैसे हमारे लोग सीरिया के रास्ते टर्की, ग्रीस, जॉर्डन जितने ममालिक में गए हैं, अगर वो वहाँ पकड़े जाएं तो 2-4 क्राइम्स की वजह से वो पकड़े जाते हैं। अगर कफ़ील के पास कागजात हैं इन अरब वर्ल्ड एंड द कफ़ील इज़ नॉट नाइस टू देम, सो दे वुड लीव द डॉक्यूमेंट्स एंड रन अवे, और वो अपने आप को किसी और मुल्क के हवाले करके उनको भिजवा देते हैं। मोस्ट ऑफ द टाइम्स दे डिस्ट्रॉय देयर पेपर्स, पासपोर्ट, ID कार्ड, ताकि आइडेंटिटी ना हो, ताकि किसी तरीके से रेफ्यूजी क्लेम करे या एसाइलम प्रोटेक्शन क्लेम करे। जब वो पकड़े जाते हैं, सो दे आर अनडॉक्यूमेंटेड। अब जब वो वापस आते हैं तो लीगल रिजीम यहाँ ख़त्म नहीं होता। एयरपोर्ट पे FIA और कंसर्न्ड अथॉरिटीज़ उनका इंतज़ार कर रहे होते हैं, क्योंकि जब आप वापस आ जाते हैं, आपके पास कोई कागज़ नहीं होता, तो शनाख्ती कार्ड जब आपका गुम हो जाए, व्हाट डू यू डू? आप FIR कराते हैं। तो FIR आप किस जगह कराते हैं? जहाँ गुम हुआ हो, जुरिस्डिक्शन उसकी होनी चाहिए। तो अब जब बाहर आपने पेपर पाड़े हैं, तो आप जब वापस आते हैं, यू आर विदाउट डॉक्यूमेंट्स, यू डोंट हैव अ नेशनैलिटी, यू कांट क्लेम अ नेशनैलिटी। तो यहाँ पे फिर लॉ कहता है कि भाई आपने अगर एक सरकारी डॉक्यूमेंट डैमेज किया है विलफुली, तो आपने तो क्राइम किया है, सो व्हाई शुड आई इशू अनदर वन। एंड मोहसिन वाज शेयरिंग अ स्टोरी कि फिर इस किस्म के लोग नाम बदलते हैं, क्योंकि वो आइडेंटिटी चेंज करने के लिए नाम बदलते हैं, फिर नाम के लिए वो कोर्ट्स जाते हैं। जब नाम चेंज करते हैं, फिर वो ID कार्ड और पासपोर्ट को अप्लाई करते हैं। सो जो ह्यूमन ट्रैफिकिंग में तो लोग ग्लोरीफाई करते हैं ना, चलें जी यूरोप चलें, या बाहर जो बहुत ही सख्त ज़िंदगी गुजार रहे होते हैं, वो जब वापस आते हैं वो असली स्टोरी तो नहीं सुनाते। वो तो गांव के हुजरे में बैठ के वो तो कहते हैं जनाब बस देखने और ना देखने वाला मुल्क है, आप आएंगे तो आपको पता चलेगा, ये सारी टाट। So that glorifies the false glorification of what they go through, वो ट्रांसमिट हो जाता है एंड इट फीड्स द ह्यूमन ट्रैफिकर्स। तो ह्यूमन ट्रैफिकर्स उनसे पैसा शैसा लेके उनको भिजवा देते हैं वो डॉक्यूमेंट। किसी को नहीं पता होता कि क्या होने वाला है, कोई किश्ती पे मरता है, कोई बॉर्डर पे मरता है, कोई पकड़ा जाता है। लकी आर दोज हु आर अरेस्टेड, और वहाँ से फिर डॉक्यूमेंटेशन का लीगल एक रिजीम शुरू हो जाता है, क्योंकि वो मुल्क कहता है इसको वापस ले लें, उसकी आइडेंटिफिकेशन होनी होती है। सो आइडेंटिफिकेशन नादरा करता है इन केस ऑफ पाकिस्तान थ्रू द फैमिली ट्री। अगर कागज़ नहीं है, बाप का नाम है, बाप का नाम नहीं है, थंब प्रिंट है। सो दिस इज़ हाउ एवरीथिंग इज़ कनेक्टेड। पाकिस्तान इज़ वेरी न्यू टू द लीगल इंस्ट्रूमेंट्स, क्योंकि पहले तो शनाख्ती कार्ड भी हाथ से लेके होते थे ना, पासपोर्ट भी मशीन रीडेबल नहीं थे। लेकिन चूंकि इंटरनेशनल एनवायरनमेंट लीगल चेंज हो रहा है, so Pakistan is becoming, it is the responsibility of Pakistan to go with the international standards of the legal regime. So there will be many new things that you will be experiencing and hearing, जो बाकी developed ममालिक कर चुके हैं। We are on the way. So the stage that we are in is a highly important stage for people like you, people like us, to go into the details and avoid superfluous information, कि बात सुन ली और लिख दी। नो, व्हाट डू यू मीन, इसका क्या मतलब है, कैसे होगा, क्यों होता है, किसने करना है, मैंने क्यों करना है, मैंने लिखना है नहीं लिखना, मैंने वीडियो प्रोड्यूस करनी है नहीं करनी, सोशल इशू को किस एंगल से उठाऊं. When Sharmeen Obaid Chinoy won the award, so many people came to me कि ये कौन सी शक्ल है पाकिस्तान के दिखाने की जो इस पे अवार्ड भी ले लिया. This was one way of thinking. But I think she did an absolutely amazing job by thinking कि यार ये एक इशू है, इसको हाईलाइट करना चाहिए. उसके बाद एक लीगल रिजीम भी बन गई. Women harassment पे I met the chairperson a year or so ago. मैंने कहा बीबी आप लोग किस किस्म के केसेस लेते हैं? कहते हैं हमारा तो वर्क फोर्स harassment के केसेस हैं. And speaking of sexual harassment, Misha Shafi and Ali Zafar were in the news yesterday. And not necessarily I agree to the news, I don't agree to the news, but the subject is there. The lady who heads the Federal Ombudsman Secretariat for Workforce Harassment, she mentioned कि कोई केस ही नहीं आता. तो अगर ख़वातीन कहती हैं कि जी हमारा लॉ तो बन गया है फ्रॉम डोमेस्टिक वायलेंस टू वर्कफोर्स हैरासमेंट, तो बना रहे. If somebody doesn't go and report, the law would die its own death. 5 साल कोई नहीं जाएगा, 6 साल कोई नहीं. फिर अगले से प्ले कार्ड उठा के कहते हैं जी प्रोटेक्शन प्रोटेक्शन प्रोटेक्शन. कहते हैं जी प्रोटेक्शन तो आपने करानी है, इंश्योर तो आपने कराना है. सो वी हैव नॉट रीच्ड दैट लीगल कंफर्ट जोन. हम पुलिस स्टेशन जाके भी घबराते हैं. हम अदालत के क्या अदालत के चक्कर लगाना, let alone a woman going and breaking the silence. I was reading the language of Misha Shafi this morning very carefully. What she has written. उसने भी कहा है कि it took me many years. अब जो भी investigative story है, as a lawyer, I would deny the story. I would say like as if this has not happened, because this is not a social media stunt. If you have an issue, there are offices. Show me the document that you have gone with evidence that this date, this thing happened, and then the legal proceedings take place. So social media is not the source. So as a lawyer, I reject it. एक चीज़ जो मैं भूल गया था, which is important for the audience, कि जो special quotas हैं for PATA and FATA, आप educational institutes में भी देखते हैं. I'm from FATA. मैं तमाम तालीमी सरगर्मियाँ under the FATA सीट्स की हैं. हमारे अपने scholarships होते थे. But we would not compete on the national scholarships, which I think now as a lawyer was a discrimination. कि जी खैर anyway, not going. 73 में 40 साल का टाइम दिया गया कि ये जो कोटा सिस्टम होगा, this will merged into mainstream. तो ये 40 साल 2013 में पूरे हो गए. इस पे आप लोग ज़रूर एक डॉक्यूमेंट्री बना सकते हैं कि जो चीज़ कॉन्स्टिट्यूशन में थी कि फाटा और पाटा और एनी रिस्ट्रिक्टेड एरियाज़ की जो एक्सक्लूसिव ट्रीटमेंट होगी वो ख़त्म हो जाएगी, और उसके साथ 40 साल का एक था. तो 2013 से 18 तक 5 साल गुजर गए, किसी ने इस पे बात ही नहीं की. तो दिस इज़ one area that you can look into, and you can look into so many other important legal areas जिसमें आपकी आवाज़ जो आपके ख़दशात होंगे, the fears that you may have, that whether the topic that I choose for my documentary or the voice that I raise, if you dip your feet in the law, then you will feel very strengthened. आपको कोई वैसे कुछ नहीं कह सकता. जैसे आपने ब्रॉडकास्टर का कार्ड निकाला, that was basically referring to, on a serious note, it was referring to that, you know, you represent somebody. So you anchored yourself to a legal entity. आप कुछ और भी कर सकते थे, कह सकते थे, लेकिन आपने ब्रॉडकास्टर का क्यों? Because instinct कि यार ये तो this is an entity which has the mandate to speak in the mic. So आपने उस राइट को अपने तहफ़्फ़ुज़ के लिए इस्तेमाल किया. इसी प्रिंसिपल को अगर तमाम ऑडियंस ऑन अ सीरियस नोट लेके आप अपनी अपनी जगहों पे सोचें कि व्हाट इज़ दैट लीगल स्ट्रेंथ यू कैन एंकर अपॉन, कि एक दफ़ा उस लीगल पिलर को पकड़ें, उसके बाद भले डॉक्यूमेंट्री बनाएं, भले स्टोरी लिखें, भले फिल्म बनाएं, आवाज़ उठाएं, nobody would stop you. With this note, I was not informed of the tea, but thank you very much. It was such a pleasure to speak to you and the questions that you had.